Hello everyone, a very good evening. This is the CAIIB Foundation June 2025 series in which we are covering the BRBL paper, all the units module wise. Today we'll be covering the unit 17D from our module C, which is enforcement of security interest. So, under the SARFAESI Act, how can the banks start or initiate with the process of enforcement of security interest? How the creditor can enforce, and what will be the role of the DRTs and the appellate tribunal, how the appeal can be filed, everything we will see. So, we know that under the SARFAESI Act, the secured creditor can enforce the security interest in his favor without the intervention of a court or tribunal. So, this power is given to a secured creditor and it has an overriding power over the provisions related to the mortgage in the Transfer of Property Act 1882. Right? The SARFAESI Act speaks about the notice to be given to the secured creditors to the borrower who has defaulted. So, before we initiate with the security interest, the borrower will send a notice to the borrower. The precondition to get the right to serve this notice is that the notice should be given asking the borrower to discharge his duties in full, his liabilities in full within the 60 days from the date of the received notice. Failure to do so by the borrower, the secured creditor can get further rights which are detailed in the act. All right, so within 60 days, if the borrower does not pay off the liability, then the initiation of the security interest will be there. All the rights will be given to the secured creditor, right? In the notice, details of the amount payable, the details of the securities will be given. Then, other than that, the overdue period, facility wise securities provided, other details can also be given. However, the Act does not contemplate a reply from the borrower to the notice. The borrower may reply or make representation to the notice so received by him, right? Then the reply for which has been received by the secured creditor, they must apply his mind to the objection which is raised by the borrower. An internal mechanism should be evolved to consider the reply of the borrower. Meaningful consideration, if it is there in the objection, then execution should be taken, right? If the borrower does not pay in full as per the notice, such non-payment by the borrower gives the right to the secured creditor to take recourse to the measures. Like they can take possession of the secured assets, they can take over the management of the secured asset, they can appoint a person as manager to manage the security, right? So, one of these measures can be taken, and when the sale of the secured asset is made, the appropriation of the sale proceeds are required to be made. Firstly, towards the costs, charges, and expenses for those who are recoverable from the borrower, like insurance premiums, etc. Second, payment towards the dues of the secured creditor. Thirdly, if there is any surplus, it will be paid to the person entitled thereto in accordance with the rights and interest. All right. If, however, the borrower pays the entire dues, then the secured creditor shall not sell or transfer the secured assets and no further steps shall be taken for the sale or transfer. Right? So, this is done in the first points. Within 60 days, the reply will be given, or within 60 days, the liabilities have to be fulfilled by the borrower, or else the secured creditor will get all the rights which are detailed in the act. Now, when the secured creditor is taking over or taking possession or control of the secured asset, or when the secured asset is required to be sold or transferred under the SARFAESI Act, then the secured creditor can take help of the chief metropolitan magistrate or the district magistrate or any officer which is authorized by them. They can take help of these officers. And for seeking such help, the secured creditor has to make a request in writing to the said authority within whose jurisdiction the secured asset or document related to it are situated. Right? So, for the compliance of the provisions, the metropolitan magistrate or the district magistrate will take such steps or use or cause to be used whatever necessary to make the transfer or sale in favor of the secured creditor. Now, what is the manner and effect of takeover of the management? So, when the secured creditor or the ARC takes over the management of the business of the borrower, they may publish a notice in a newspaper. This notice should be published in two newspapers, in a English language newspaper and in a newspaper which is published in an Indian language in circulation in the place where the principal office of the borrower is situated for the appointment of as many persons as it deems fit. All right, and on publication of such a notice, the directors of the company, the person holding any office, direction, and control will shall be deemed to have vacated their office. So, this publication of notice is important, right? And then, after the appointments of directors or administrators will be done, will be appointed. All right. So, there will be no compensation to the directors for the loss of office in this regard. There's also the provision of making an application against the measures to recover the secured debt if any person, including the borrower, is aggrieved by any of the measures which are taken by the secured creditor for taking possession of the security, then they may make an application along with the prescribed fees to the DRT having jurisdiction within 45 days from the date on which measures are taken. So, when under the SARFAESI Act, the secured creditor is taking any measure, any step, and any person is aggrieved by that order, they can make an appeal to the DRT within 45 days on which such measures are taken, right? And obviously, the application is required to be filed before the DRT within whose local limit the jurisdiction of the cause of action is there, or where the secured asset is located, or the branch or the financial institution is maintaining an account, right? If the DRT, after examining the facts and the circumstances, they come to a conclusion that any of the measures which are taken by the secured creditor are not in accordance with the provisions of the Act, then they can declare the recourse to any one or more measures to be invalid, or they can restore the possession of the secured assets or the management to the borrower or any other aggrieved person. They can also pass such other direction as they consider appropriate. However, if the DRT declares that the recourse taken by the secured creditor is in accordance with the provision, then the secured creditor shall be entitled to take recourse to any one or more of the measures to recover the secured debt. All right. So these two decisions can be taken by the DRT. Appeal can also be made to the appellate authority. The appellate authority, any person who is aggrieved by any order made by the DRT can prefer an appeal along with the prescribed fees to the appellate tribunal within how many days? Within 30 days. Within 30 days. Right? And this fees can be prescribed, it can be different for the borrower's appeal and an appeal by anyone other than the borrower. All right. Other than that, the time limit which is given for the disposal of the complaint, the DRT has to dispose of the application in accordance with the provisions of the Recovery of Debt Due to Banks and the Financial Institutions Act, the DRT Act of 1993. The application has to be disposed of within 60 days. Within 60 days. And we have already seen that a higher appeal can also be made to the DRAT. Now, according to the amendment which was made to the Act in November 2004, it has stipulated that no appeal can lie unless the borrower deposits 50% of the debt which is claimed by the secured creditor. Again, the tribunal has powers to reduce this amount to 25% of the claim. Then there are the rights of the borrowers for the compensation and the cost as well. And that is all. So now if you want to study, if you want to uh, learn all of these provisions in detail, then you can join the CAIIB Super Elite plan, which is the all-in-one plan. You will get live classes, mock tests, and downloadable PDF notes of all the papers. You'll also get the sectional and full-length tests, everything under one plan. And if you join the course now, you can use the code CHAMP and avail 50% off on your subscription. So join the course now, start with your preparation, and I will see you again tomorrow with the next unit. You can download the PDF from the link which is given in the description box. Make sure that you like, share the video and subscribe to the channel so that you do not miss any of the updates. Thank you so much.